Our next speaker is Neil Wehneman. He's currently the Development Director for the Secular Student Alliance and one of our newest hires. Prior to joining the SSA, Neil litigated commercial disputes, conducted intellectual property transactions, and drafted scientific expert witness testimonies. Long sentence. Member of the bar in Ohio, Indiana, and the United States Patent and Trademark Office. Neil holds degrees in Information Systems, cum laude, from Ohio State Fisher College of Business, and Law, summa cum laude, from Indiana University McKinney School of Law. What my favorite part of his story, he was raised a fundamentalist Christian. He was active in Campus Crusade for Christ in college. Following law school, Neil solicited book recommendations from his atheist and fundamentalist friends so that he could critically re-examine the faith of his childhood. After considering the best arguments, the leading sides had to offer, he abandoned Christianity as not only unproven but affirmatively contrary to the evidence. He's an avid board gamer and previously served as the assistant director of the Jack Vassell Memorial Fund, a leading gaming charity. And if you have spare time, ask him about his days in Campus Crusade for Christ. There were SSA groups on his campus at the time. Today, Neil will be presenting on the legal rights of secular students. Please help me in welcoming Neil Wehneman.
Hello, everybody. Give me 1 second. Get the presentation working out. Fantastic. So, as Evan mentioned, my name is Neil Wehneman. I'm on staff with the National Secular Student Alliance. And today we're going to be talking about your legal rights as a secular student. As I was outlining this talk, I was like, you know what, I could probably turn this into a 2-credit-hour law school course. And I've been told I have 20 minutes, so buckle up. So, for background, I'll tell you a little bit about who I am, the problem that we're looking to solve, and how it is that we're looking to solve it. So, again, I'm the development director with the SSA. I'm admitted to practice law in Indiana, Ohio, and before the USPTO. Previously done intellectual property work, commercial litigation, and expert witness testimony. So the problem that we're looking to solve, there's 4 parts to this problem. First off, do schools, whether they're high schools or colleges or universities, do they understand their legal obligations when it comes to secular students and secular student groups? Second, do these schools and their administrators, do they accept these obligations? Are they willing to actually follow the law? For students, do you know what your legal rights are? And just as importantly, do you know how to enforce those rights? 2 people that a lot of you in this room may be familiar with, Jessica Alquist and Daniel Koster. There's some student leaders who ran into some issues with their legal rights, and they stood up and said, no, this is unacceptable. And the secular community and other organizations rallied around them. And with Jessica, had a fantastic outcome with the prayer banner being taken down. And with Daniel Koster, FFRF recently filed suit regarding the viewpoint discrimination within a limited public forum that was opened up by his school. So we have a lot of student leaders that are currently standing up and saying, I have rights, and I'm going to ensure that those rights are enforced. We have a lot of other student leaders, or would-be student leaders, who aren't certain of their rights, aren't certain of how that they can get those rights enforced. And a lot of times, these violations and these problems aren't even getting onto the radar of national organizations because students are deciding, I'm not going to fight this. I'm going to let this go. And so we're looking to help solve that problem. And a specific way that we're going to be solving it is I'm excited to announce a partnership between the Secular Student Alliance and the Freedom from Religion Foundation. Yes, I'm extremely excited by this. And the outlines of that partnership is we have put together a secular public high school students' Bill of Rights, which is outlining here are some, not all, but some of the most significant rights that you have, and we are prepared to help you defend those rights. We're also going to be putting together other resources, such as presentations like this at conferences, other training materials, etc. And perhaps one of the most important parts of the partnership is the close collaboration between our organizations, where we can ensure that those that are seeking legal support from FFRF can become student leaders within the SSA, and those that are student leaders within the SSA can get the legal support that they need. We're also going to be raising awareness of the rights and resources that are available to secular students, so that those students that aren't on our radar know that, hey, I can reach out, I can get help. There are people that have my back. Also, with FFRF, they receive thousands of complaints a year, and they have committed to prioritizing the student complaints to ensure that we're getting action taken on these violations. So obviously you guys can see me, but somebody I specifically want to call out is Andrew Seidel with the Freedom from Religion Foundation. The rest of the material in this presentation, there's probably been about a dozen people that have had their hands in it, but Andrew has been fantastic working with me to refine language, et cetera, and I want to specifically call him out and say thanks. So something that we need to mention is that there's different types of students. The baseline for this presentation is a public high school student. So we've got two separate phrases there that are underlined. The First Amendment and the Equal Access Act underlie many of the rights, and those specific pieces of law require state action. So generally, if you have a private institution, they're not necessarily going to be bound by the Equal Access Act or the First Amendment. However, California happens to have a piece of regulation which requires First Amendment protections on private campuses with some religious exceptions. That's very much the exception. We're generally dealing with public institutions. If you happen to be a public college or university student, you're going to have a slightly different set of rights. So for example, the Equal Access Act does not apply to colleges and universities, but the Establishment Clause does, the Free Speech Clause does, and other sources of law. So we're going to be talking primarily about the high school student Bill of Rights. However, regardless of where you're at in your educational journey, the 2 points that I want to make certain you walk away from are that you have the same rights as everybody else, and we've got your back. If you take nothing else, take that from this presentation. So, the foundation of the partnership between SSA and FFRF, the Secular Public High School Students Bill of Rights. Something I want to say on the front end, and thanks to Dan Barker for suggesting this, is that the Bill of Rights that we're going to be talking about is a recognition. It's not a grant. So just like with the original Bill of Rights of the federal Constitution, our founders were not saying, here's new rights, here's new powers we're giving you. You already have this. You've always had this. We're simply making it clear and plain what you have, and this is the ground that we're definitely going to be assisting and supporting you on. So very briefly, here's the first 5 rights. To give you an idea where we're going, we're going to be walking through each of these in turn, so I'm not going to speak through this slide. And here's the second set of 5. And we'll go ahead and get started with the first right, which is the right to an educational environment. So the text of this right is you have the right to an educational environment free of religious proselytizing or bias from school employees. So this to me is kind of like in the federal Bill of Rights, in that the right of free speech animates and helps protect all of the other rights. And if this is probably the most important one as far as saying most of the other violations we see, most of the other rights that we need to call out are based upon bias against secular or non-theistic students. So for this particular right, common violations that we see are the 10 Commandments being put in a special place within a public high school. School employees encouraging religious activities during the school day, intelligent design being taught as science in science classrooms, or the peer-reviewed, generally accepted science of evolution being refused on religious grounds. So those are situations in which you're not being given an educational environment. You're being given a religious environment. Something that's very important as far as with this right saying that you have the right to an educational environment is that the entire reason that we have compulsory education is to ensure that we have an engaged and educated citizenry that can then go out and decide what is best for you. Make your own decisions, live your own life, contribute to society, as opposed to you being indoctrinated into the majority's religion. The second right, the right to be free of school-sponsored religious rituals. So the text of this right is you have the right to be free, as apparently it got changed to font color, to be free of school-sponsored religious rituals, including prayer, at school functions, whether conducted by staff, students, or outsiders. So again, you are there to learn. You are not there to be indoctrinated into the majority's religion or anyone else's religion, for that matter. So when schools bring religious speakers onto campus, when we have teachers or coaches that are praying with students, when we have prayers at graduation or graduation is being held in churches, we have a problem. We have a violation of this right. Third right is the right to free speech on campus. So this text, you have the right to free speech on campus in accordance with school policies that apply equally to all students. The First Amendment, the right to free speech, is critically important, but it is not an absolute when it comes to school campuses. Tinker v. Des Moines is the leading case on this. We have numerous other cases that are interpreting that case. But the real crux of it is that if the school is going to be restricting speech, they have a substantial burden to show that it's necessary, and it must apply equally to everyone. So we cannot have secular speech being singled out. We cannot have a facially neutral policy that's only being enforced against the unpopular speakers, perhaps the non-theistic students. We also can't have viewpoint discrimination when a limited public forum is being opened up, as we're currently seeing in Florida. So these are all violations of your right to free speech on campus. The fourth right, you have the right to form a secular student group. So you have the right to form a secular student group, such as a secular student alliance, if your school allows extracurricular student groups. This is primarily enforced through the Equal Access Act, which says that any secondary school, essentially high schools, that receive federal funding, if they allow extracurriculars, if they allow student groups to form, then they have to allow all student groups to form. So if your school is going to allow extracurriculars, then you have the right to form an extracurricular that is focused on the needs and interests of secular students. Relatively straightforward. The fifth right is actually a corollary to the fourth one, the right to organize your student group. So you have the right to not only be told, okay, fine, we'll let you have your group, but you have the right to actually create the group, to organize your student group without intimidation, undue interference and burdens, or requirements unique to your group. So oftentimes what we see is an administration says, okay, fine, you guys can, form your secular student alliance or whatever it is you want to call yourselves. But we've got all these new hoops that you and you alone get to jump through. We're going to require you to come to a special school board meeting 3 months from now, where you can plead your case, and we're going to hold a special vote, and maybe we'll let you have the group, maybe we won't. Or we're going to create new requirements that just apply to you. Oftentimes we see issues with faculty advisors, where either the faculty, nobody will want to sponsor the group, and so you kind of have this little, almost a silent veto, and so you have the right, if no faculty advisor will agree to sponsor your group, to have one appointed or to have the principal do it. The key thing is that you cannot have special restrictions that are against you. So you have the right to actually create the group. You have a right in practice, as opposed to simply the right to, okay, fine, you have this theoretical right to form your group. The sixth right is the right to affiliate with a national organization. Again, we're dealing with the Equal Access Act, and one of the requirements of the Equal Access Act is that the group must be student-led. It cannot be controlled by an outside organization. With the Secular Student Alliance, we have our 4 minimum standards of affiliation, and any group that meets those 4 minimum standards is eligible to affiliate with us. And part of the reason that we created those minimum standards of affiliation is, first off, to ensure that any group that we are providing support and resources to is consistent with our mission, but also to ensure that we're not controlling the groups, that the individual student groups get to decide, this is what is most interesting to us, this is what we want to focus on, whether it's community, advocacy, service, education, etc. And so we often see violations of this right with the school saying, well, you guys need to call yourself a philosophy club. We're not going to let you actually call yourself a secular student alliance. Or if they just say, no, you can't work with the National SSA. That would be control, and it's not control. It's support, it's empowerment, it's resources, but you guys ultimately get to call the shots. The seventh right, the right to equal treatment regarding group privileges. The text here, you have the right to be treated the same as all other student groups regarding advertising, publicity, funding, programming, and all other privileges and activities. So the school generally gets to decide, okay, we're going to allow groups to have this much money from the university, we're going to let people put up flyers, not put up flyers, they have to get this advance approval, whatever, and that's perfectly fine. The school gets to decide what is the set of privileges that are available, but those privileges must apply equally. And so if other groups have access to the announcements, congratulations, you have access to the announcements as well. If other groups have the rights to put up flyers or to bring in guest speakers, you have those same rights. So again, the school gets to decide what is the set of privileges that are available broadly, but they don't get to decide that the popular groups get set A and the unpopular groups get set B. It's the same privileges. The eighth right, the right to evaluation based upon your actions. The text here, to have the administration evaluate your group based upon your actions and intended actions, not fear, prejudice, or how others might respond to those actions. So what we have going on here is that oftentimes a group will form, and they'll be told by the administration, well, normally we let people do X, Y, and Z, but, if you guys do X, then, this other group's going to get really upset, and they're going to make a disruption, and so we've got to limit you. We've got to say you can't do this. And that is incorrect under the law. You have the right to be evaluated based upon what it is you actually do, based upon what it is that you say that you're going to do, and not based upon how others might react to you. So these preemptive limits violate this right. If your group gets punished based on somebody else's heckler's veto, or somebody else gets obnoxious because they don't like the mere fact that you exist, that is that other person or that other group's problem. They're the one that the administration needs to deal with. You still have the same rights to do what everyone else does, whether it's putting up flyers, whether it's holding events, whether it's simply talking with your fellow students. You're allowed to do that. It's those other people that are breaking the rules, that are being obnoxious in response, that the administration has to focus their efforts on. The ninth right, the right to complain. You have the right to complain to your school or to contact the media about violations of any of these rights. When we were drafting this right, we went back and forth over whether we were going to call this the right to complain, the right to be heard, something else. The right to complain sounds kind of whiny and has kind of a negative connotation to it. But the more that I thought about it, most of the time when somebody files a lawsuit, it's entitled complaint. Whether it's complaint for damages, complaint for breach of contract, this is a legal term of art. This is how we get things started. This is how we resolve disputes. So you have the right to complain. And specifically, you have the right to complain to your school or to the media. Your choice. You are not under an obligation to go to the school first and say, this is a real problem, we need to fix this. You want to call up your friends in the media or whatever, you have the right to do that. Now, it may make sense to informally go to the school and say, let's talk about this. Let's try and sort this out. Oftentimes, that'll save you time, that'll save you hassle, that'll save you energy. But if you've got a situation where you've got a repeated course of conduct where they are just saying, no, we're not going to work with you because we don't like you, then you don't have to informally resolve it. Common violations of this right is where a school will simply refuse to listen to you, or maybe they'll just keep scheduling it, and then, oh, no, we had a conflict, we got to push it back, let's see if we can run out the clock and get you guys to graduate, go away. Or, like the case of Caitlin Campbell in Charleston, West Virginia a few months ago, threats regarding media contact, or if the school is insisting on time for informal resolution. It may be in your best interest to actually give them time to informally resolve that, but you're not obligated to. The 10th right, the right to legal recourse. So, you have the right to seek legal recourse, including from national groups like the Freedom from Religion Foundation, if your school violates any of these rights. So, you guys can't work it out. If they don't want to listen to reason, as unfortunately as often is the case, you do have the right to legal recourse. Without enforcement, the law is merely a suggestion. These are not suggestions. These are rights. So, my last slide is how to get in touch with us. On the left-hand side is my direct dial number at the office. You're welcome to give me a call. You can get my card. You can get the cards of other staff members if you prefer email or other ways of reaching out to us. That's how you get in touch with us. On the right-hand side is FFRF's preferred means of having first contact. You can also give them a call. They've got contact information up on their website. So, like I said, a lot of information. These are the end of my slides. I am happy to take questions and discussion. Go for it. Well, we've got a couple of issues there. The First Amendment doesn't cover hate speech, and there's a few other exceptions to the First Amendment, and so you'd have to be looking at where is the dividing line from where it's really no longer constitutionally protected speech. We've also got issues where oftentimes the disruption is being caused by outside groups, where somebody else is going to respond extraordinarily negatively to it. We also have situations where with Tinker, there is a little more flexibility that is given to the school environment. It's not where the school gets to decide willy-nilly. you know, we like this group, we don't like this group. So with that, with the secular groups, with the Secular Student Alliance, we are firmly within the this is a right that secular students have. As to some of the other examples you gave me, I need to be diving into the case law. In fact, I'd probably be deferring a bit more to FFRF on that because they litigate those issues quite a bit more than we do. So there's a couple different issues at play there. Yeah, that would you probably want to be looking at groups that because the white power groups, the communist groups, that's very much getting away from where SSA's focus is and where FFRF's focus is. So yeah, I would be looking at ACLUs and those other groups. Other questions? Yes, we actually have the 10 rights that are currently undergoing graphic design so that we can have something that's quite pretty. We've also got some other text where we've basically got a longer version of this talk that in the coming weeks we expect will be up on the website. Yes? Yeah. The big one's going to be the Equal Access Act, which is saying that you know, you have the right to form these groups if you're at a high school that's receiving federal funding, which is pretty much any public high school. So you're not going to have the same Equal Access Act rights. Let me actually take a quick look as I flip back to the list. Well, again, it's not the Equal Access Act isn't going to be the source of those. Most of these are actually, I think the main difference is going to be kind of around the edges of it, as far as, I'd actually like to talk with you afterwards on that, so, if that's okay. So, fantastic. Other questions? Thank you.